Hey, good morning, friends. It's John Hart back with Cracking the Code, how to end the financial drain of the family court system. I'm joining you from the backyard of my in-laws' house on this beautiful Sunday morning. Sadly, we had a death in the family, so we came down here for the funeral. There's a lot of good resources and information coming out right now for moms and dads that are going through the family court circus. And that's what it is. It's a circus. It's a financial racket. Up to this point, I have always presented original content based solely on what I've learned from my own personal experiences going through the family court racket or circus and dealing with all the flying monkeys of the family court system. The guardians ad litem, the forensic investigators, the child custody investigators, DCF, Child Protective Services, whatever they're called in your state. I might have said already guardians ad litem, and the social investigation people. Now, thank God, I've learned so much from watching other moms and dads reach out through social media, talking to all of us about how much of a financial racket that is, that I was able to walk away from that. I was also able to get rid of a guardian ad litem who was doing literally nothing for the case, and was only at this point trying to allege that she would stay on the case and work pro bono or for free. But really what she was doing is she was railroading me into a solution with a reunification therapist, which is a garbage term. It's just a court thing. It doesn't really reunify anything in my situation. But it's all about referral fees. I don't usually plug other people's YouTube channels. As of the time of this video, I'm not monetizing off of this, and there's no problem with that. I have no issues with that. But I'm gonna throw one out there to another dad who has his own YouTube channel. It's called Father's Rights and Resources. His name's James. I've spoken with him one time on the phone. I've never actually met him, but I'm gonna kind of be a poser today a little bit. But this one, the credit goes out to James from Father's Rights and Resources, #HowIGotCustody. He and I approach things a lot from the same way, and I didn't realize how similar our approaches were until I started watching more of his videos. You got to shut it down. And so today what I'm going to share with you is something that I'm actually stealing from him, but I'm giving him credit, and he's a good dude. And if you have the opportunity to reach out to him as a dad, I guess moms can as well, but reach out to him, Father's Rights and Resources on YouTube. I think he lists his number, and it's #HowIGotCustody. Anyway, so that's where credit is due on this video. There's just about every state in the country has a chapter that deals with marriage, dissolution of marriage, and custody issues. In the state of Florida, it's Chapter 61. Specifically, Chapter 61.13 talks about the best interests of the minor child. It is never in the best interest of a child to not have their loving, meaningful relationship with their father. It's never in the best interest. It's in the best interest of a child to have their mother and their father in their lives because of the attachment bond. Now, even in the event that you were previously an abusive person, that can be identified, it can be diagnosed, and you can be healed yourself, and the family can be reattached. Remember, there are fathers out there that have been adjudicated guilty of manslaughter, murder, that are free now, that have a relationship with their children. Rapists that are out of jail that have a relationship with their children. Violent people who are now out of jail or serving probation that have a relationship with their child. If you're going through family court and your ex is heralding allegations towards you or whatever, bring that up in court. Make sure you say very, very succinctly to the judge that all the statistics show that there's a 10, 20, 30, or 100-fold increase on teen pregnancy, drug use, crime, academic failures when it comes to a child not having guidance or structure from their father in their lives. We know it. We see the statistics. We understand these statistics. It's incontrovertible. We know it. So what I would recommend is that when you're making your argument in court, If you have an attorney, make sure they make this argument, and hopefully they do. If you're representing yourself, which means you're pro se, to represent oneself in court, even better. Put it on the record. Your Honor, for the record, I am ready and willing to be a father and participate in the lives of my children. If there is any reason why my ex-wife, for example, thinks that I should not be in the lives of my children, then there needs to be a finding of fact with conclusions of law as to why. Put it on the record. We have to stop playing this family court game where we are going from guardian ad litem, making a referral to a social investigation after they don't do their job, and then to this therapist that you don't get a chance to choose, doesn't take your insurance, you're paying money out of pocket. It's a giant money pit. Stop throwing money into the money pit. Be willing to walk away. Not that you want to, not that you genuinely don't want to be in the lives of your kids, but you got to be willing to walk away from the situation to protect them. Your number one obligation in this world, if you have minor children, is protect those children. It's to keep them out of harm's way. And if the court, upon the recommendations of the idiotic child custody evaluator or the forensic psychologist, social investigation people, or the non-properly educated guardian ad litem, whoever these clowns are recommending some sort of thing for you to throw a bunch of money at that does not provide children any type of therapy or treatment protocol, and that only puts them through more testing, investigations, and evaluations, say no. If there is not a concurrent therapeutic capability or treatment protocol based upon a diagnosis that is based upon established knowledge of the DSM-5, for example, say no. We have to start educating judges, attorneys, guardians ad litem about what's going on and about the fact that we're no longer participating. But remember, even after you educate them, they still have very little interest in fixing the problem, because the problem not being fixed generates billions of dollars a year in family court revenue from innocent moms and dads who just want to be in the lives of their children. That is the path we have to go down, and that is the path we need. If there's a million of us going through this nonsense and we stop sending money to family court Looney Tunes and put that money away in a trust or in a savings account, whatever you want to do, however you want to invest, put it somewhere for your kids one day. That's what's in the best interest of the children. Therapy, treatment plan, that's what's in the best interest of children. They don't need to be sitting there answering questions for the next 8 to 12 months and not getting therapy at the same time, just so the family court can check the box and sideline you and pigeonhole you into some sort of financial racket. James from Father's Rights and Resources calls it a hustle. I agree with him there. We're just using different terms. But it's a hustle. It's a racket. Stop participating. Drain the system and you stop the problem. Drain it. Happy Sunday. Love you guys. Have a great week. Bye-bye.